welcome back to our YouTube channel. I want to talk to you today about dangerous driving, specifically the sentencing for dangerous driving. We represent a lot of people charged with dangerous driving. So let's assume a client of ours pleads guilty to a summary conviction dangerous driving charge. And by the way, dangerous driving is when there's like a marked departure from the norm of driving. And I'll give you a couple examples. Let's say someone's driving 130 kilometers an hour through downtown Toronto. That would be probably per se dangerous driving because it's a danger to the public and it's certainly a marked departure. Or someone who's weaving in and out of traffic dangerously and causing people to swerve, etc. So there's a whole panoply of a range of dangerous driving, but there's two very clear examples where a person would be guilty if the witnesses were believed. So what would happen if the person's found guilty or pleads guilty? Well, what happens is this: a judge on a first-time offense, there's a mandatory minimum fine of $1,000. Now the fine could be much higher than that too. That's the mandatory minimum. So that would be more to like a very low level dangerous driving where the person wasn't really that dangerous, as opposed to, causing mayhem on the roads and almost causing accidents. You could face a jail term under that scenario. The judge also has discretion to prohibit the person from driving for a period of 1 to 3 years for a first offender. Typically, a judge on a first offender will do 1 year. If it's really serious, bad situation, it may be higher. Maybe they'll go 18 months. I rarely see a judge go 3 years. I don't think I've seen that on a first offender before, but I've seen 2 on a very bad situation. And as I said, you could face a jail term. We've had clients who, boy oh boy, it was really bad, dangerous driving. Someone could have been killed. It's on the 401. Judges look pretty dimly on that. So we try and minimize the jail term as much as possible in that situation. Now, even if the judge decides not to take your license, there's a catch-22 because the ministry automatically takes your license for 1 year anyway. So it's the same 1 year. So if the judge takes it for 1 year, the Ministry of Transportation Ontario also suspends your license for 1 year. So don't get all excited if the judge forgets to impose the discretionary driving prohibition. So what happens for a second or a third offense? Well, on a second offense, the person's facing a mandatory minimum 30 days in jail. Could be much higher than that too. You want to get it to the mandatory minimum. For a third offense and subsequent offenses as well, you're facing 120 days mandatory minimum. So it's a serious offense. In hiring a lawyer, you're trying to minimize, you're trying to win, of course, if you can. These are for people who are pleading guilty, of course, this is what they're facing. But it's a very serious offense with serious penalties. And the mandatory minimum, yes, often we can get that. If it's more serious, of course, it's going to be a higher fine, if not a jail term, if it's really horrendous driving. So there you have it. There's a little primer about sentencing for dangerous driving. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.